do the introduction and turn it over?
Yep.
Perfect. All right, good afternoon, everybody. Thanks for joining us here. My name is Daniel O'Neill. I'm the chair of the HYLA CLE committee for the bar year that's just about to end. It's been an honor being the chair of the CLE committee for the past 3 bar years. We've been able to arrange a great slate of programs such as this one. But seeing as I'm no longer going to be a young lawyer at the end of the bar year, you all are going to be seeing a new, fresher face take over the HYLA CLE committee when the new bar year starts next month. So we have a great speaker here today. You all may recognize him from the very first presentation we had for the bar year, where he presented on statutory interpretation. So Daniel Olds is a senior attorney with Clark Hill in Dallas. He represents public and private entities in a wide variety of litigation from inception through the appellate process. He previously served as a lead appellate attorney for expunctions at the Texas Department of Public Safety and as a briefing attorney for Chief Justice Jim Wright of the 11th Court of Appeals in Eastland. He received his law degree from the University of Georgia and his undergrad from the UT Austin. Daniel, take it away. Thank you very much for presenting this one.
Well, thank you, Daniel. I appreciate it. And thank you, everyone, for coming today. I'm intending this presentation to be a very sort of high-level presentation that kind of hits on some of the high points of doing an appeal. My intended audience, you all, I assume maybe you've done no appeals and maybe you're going to have an appeal in the near future, or maybe you've only done 1 or 2 and you're looking for some tips. That being said, if you have any specific questions, I do want to leave some time at the end for questions. So if you want to go more in depth on any of these topics, I'm happy to talk about any of these topics more in depth. We could probably spend an hour on each one of these. But again, I really want to provide a sort of high level understanding of just how the appellate process works, how the courts of appeals work, how you go about filing an appeal, and just some general tips for briefing and oral argument and things like that. I also apologize. I'm recovering from COVID. I've recovered, but I still have a bit of a raspy voice, so I apologize for that. But again, if you do have any questions during the presentation, feel free to put those in the chat function. Otherwise, again, I will try to save some time towards the end for questions. All right. So before we get into why you might want to appeal, I just kind of wanted to briefly overview what the appellate court structure looks like in Texas. And I wasn't sophisticated enough to put a picture of this up on the PowerPoint. But basically, obviously, you have trial courts, you have district courts, you have county courts of law, things like that. If you want to appeal, there are 14 intermediate courts of appeals to which you might appeal from a trial court judgment. And then there's the Texas Supreme Court, which handles all civil appeals and which has discretionary review, meaning that they choose which cases they want to take. They don't have to take your case. And the Court of Criminal Appeals, which hears only criminal cases, and again, chooses which cases they want to take. Unlike the Texas Supreme Court, all of the Texas intermediate courts of appeals have to hear your appeal. So if you file an appeal, they have to address it. They can't just refuse it just because they don't want to hear it. So that's one thing. Another interesting thing for y'all, especially in Houston, is that you have 2 courts of appeals with overlapping appellate jurisdiction. So there's the First Court of Appeals and the 14th Court of Appeals, both of which cover the exact same geographic area. And if you file an appeal from a trial court in Harris County, Fort Bend County, you don't know which court of appeal you're going to be routed to until you actually file your appeal. And then they have a system for figuring out which court it's going to go to. I think it's just a random process. And sometimes that can be a little confusing for folks in Houston because sometimes the First Court of Appeals and the 14th Court of Appeals don't agree on issues of law, and the case law from each court is different. In which case you have a really interesting conundrum about, do you appeal? What are your chances of appeal? Which you don't know until you actually file your appeal. So that's a really interesting quirk for all of y'all in Houston. But generally speaking, when you file an appeal, you know which court you're going to go to. There were 14 different courts of appeals. Again, Houston has 2 with overlapping jurisdiction. There's a Dallas Court of Appeals, Austin, San Antonio, Waco, all different kinds of courts of appeals spread throughout the state. And the other interesting thing about the courts of appeals in Texas is that they vary in size quite a bit. So as Daniel mentioned, I worked for the 11th Court of Appeals in Eastland, which has 3 justices. If you're in Austin and you appeal the Austin Court of Appeals, the Third Court of Appeals, you're going to have 6 justices that that the panel may be comprised from. Dallas and Houston, San Antonio obviously have a lot more, which is interesting. We'll come back to this a little bit later, but what's really interesting about that is, your panel is going to be 3 justices normally. And if you don't like what they've done and you want to file for motion for reconsideration en banc, which means have the entire court hear it, if you only have 3 justices, you're going to get the exact same panel and it may not be worth it. But if you're, say, at the Dallas Court of Appeals, you may get different perspectives and it may be worth doing that. But we'll get into that a little bit more in a little bit. So why might you want to appeal? Say you're in the trial court, you get a result from the trial court that you don't like, right? Maybe they granted a summary judgment that you didn't agree with, you were the non-movement, and you say, I think they got that issue of law wrong, and I just don't like the result. I think my client should win. My client lost. Want to appeal it. Maybe there's a broader issue that your client wants settled. So this comes up a lot if you represent, a company that's a big player in an industry that has an issue that's sort of percolating. That's sort of a time when you want to sit down with the client and say, do we want to try to resolve this for everyone? In which case, your client's gonna be paying for it, but it's also cool for you because then you get to maybe want to get this issue at first impression, and there's maybe a greater chance that it's going to go even to the Texas Supreme Court. So again, we'll talk about it in a little bit. Again, I want this presentation to focus more on traditional appeals, but there's something called mandamus. And if your client is going to suffer irreparable harm because of something that the trial court has done, then you may want to file a mandamus petition. The classic example of this is if there's a discovery dispute and the trial court orders your client to produce some sort of information that's maybe confidential or a trade secret, something like that. And once the cat's out of the bag, there's no putting it back in. And so you say, well, we really need to stamp this out before it becomes an issue. My client's going to suffer irreparable harm if we don't get this remedied right away. And then in which case you might want to file a mandamus petition with the Court of Appeals. So can you appeal is the second question you want to ask. So you see we have our favorite trial judge here from my cousin Benny. And sometimes trial judges are going to do things that you don't like. They're going to issue rulings you don't like. They're going to issue judgments that you don't like. They're going to say things to you or your client that you don't like. They're going to act a certain way that you don't like. And you can't always appeal something that you don't like from the trial court, right? So you can't just go around saying, I don't like what the trial court did. I'm going to just file an appeal right now. It's a little more complicated than that. So generally speaking, you can only appeal from final orders of the trial court. What does that mean? Final order or final judgment is a judgment that disposes of all parties and claims. That's the general rule, right? So again, going back to our summary judgment example, if the trial court renders summary judgment against your client and it says that they're ruling on all the claims made and there are no outstanding counterclaims, and that summary judgment is final, right? It is disposed of all the parties, so we know a party who wins and loses, and all the claims are taken care of. At that point, you have a final order that you can appeal from. But again, this is something that we could spend a lot of time on. What is a final judgment? What is a judgment that you can appeal from? You have to also look at the language of the judgment sometimes. And there's a lot of case law on this. This is a really good case to read from the Texas Supreme Court if you're more interested in this. But sometimes, you can look at the language of the order, even if it doesn't dispose of all the parties and issues. If the order from the court says it's a final judgment, disposes of all parties and issues, even if it doesn't really do that, even if the court hasn't ruled on all the issues that are pending, it might still be a final order. in which case your appellate clock will start to run, and you need to look at that and determine whether or not you want to file an appeal. But again, this is a really complicated area. Generally speaking, a final judgment is one that disposes of all parties and issues. But the judgment, the language of a judgment cannot make a generally final order unappealable, but it can make a generally unappealable order appealable. So what that means is, if you have an order that disposes of all parties and issues, but the language in the order says this is not a final order, that doesn't really make it not a final order because it's disposed of all the parties and issues in the case. But if you have a judgment that doesn't seem to dispose of all the parties and issues in the case, but the language of the judgment says that it does, then it might be a final order. If that makes sense. So again, just another example, if you've, let's say you're the movant and you filed a motion for summary judgment, and you don't say it's a partial summary judgment, you say it's a full summary judgment, but let's say you left the court awarded you attorney's fees, but it didn't determine what the attorney's fees were. It said, we're going to figure that out at a later time. We're going to hold a hearing. We're going to put on evidence about what the attorney's fees are. That is not a final order, right? Because it is not disposed of all the issues in the case. Now, putting that to the side, sometimes you can appeal from an interlocutory judgment. Interlocutory is just a fancy word for a judgment that's not final yet. So there are some statutory exceptions to the final judgment rule. You can generally find these in Texas Civil Practice and Remedies Code section 51.014. And there's a list in that statute of types of orders from the trial court that you can immediately appeal. So some of the big ones are temporary injunctions, granting or denying a temporary injunction, pleas to the jurisdiction if one of the parties is a governmental entity or a government employee, TCPA, the Texas Citizens Participation Act, the anti-SLAPP statute. You used to see these a lot. This used to comprise a big part of the intermediate courts of appeals docket because it was so easy to file a TCPA motion, and it covered so many different cases. People would immediately file a motion, an anti-SLAPP motion, and it would get appealed up to the Court of Appeals. And I think at one point there was one Court of Appeals where half their docket was comprised of these sorts of cases. As you probably know, the legislature has since amended the TCPA significantly, and so I think a lot of those appeals have been cut down. But you used to see this a lot. You still see it sometimes. And then Menbau expert report cases. Before you file your appeal, you might want to consider, should you file something else first? So let's say you've got a final judgment. You want to figure out, if you're going to appeal, but maybe you should first file something else. So one thing you might want to file is a motion for new trial, especially, if there's like a default judgment against your client and you didn't find out about it until after it was entered. A motion to set aside a default is really a motion for new trial. You may want to file a motion for new trial, right? Motion to modify the judgment if you don't think it accurately reflects what the judge said, what y'all talked about at the hearing, even if you lost. You may want to modify the judgment, move to modify the judgment just to make that clear. One thing I really want to draw everyone's attention to is a request for findings of fact and conclusions of law. If you have a bench trial or any sort of evidentiary hearing that produces a final judgment, I would highly, and you're thinking about appealing, I would highly recommend that you consider making a request for findings of fact and conclusions of law. This is another topic that we could spend, an hour on, but the big reason I think that you want to file something like this is because it will narrow your issues for appeal if you do decide to appeal. It's sort of similar to, when you appeal from a jury trial and there are jury instructions and the jury makes findings. If the trial court is doing that, you want to know what those findings of fact are, what the court relied on to make its judgment, and also what the law was that the court decided. And again, this really narrows the issues for appeal, because if you don't do this and the court just issues a blanket order saying, this motion to dismiss is granted or whatever, and you appeal that, the Court of Appeals is going to uphold that judgment if there's any way to do so that's supported by the evidence. right? But if you have a request for findings of fact and conclusions of law, and the court makes those findings and lays out the conclusions of law, then you know why the trial court did that, and you can just focus on attacking those specific findings and conclusions of law. I have won reversals at the courts of appeals because I made requests for findings of fact and conclusions of law following a bench trial. It's very important. It's something that the Court of Appeals really looks at. And it's very helpful for just narrowing those issues. It also extends the appellate deadline, as we'll talk about in a moment. But it's again, I would highly recommend doing this if you have some sort of bench trial or evidentiary hearing at the trial court that you want to appeal from. And along with that, again, we can talk more about this, but there are very strict deadlines that you have to comply with in order to do that. You have to make the request, I think it's within 20 days. And then if you want to preserve, sometimes trial courts don't like making those findings because, for whatever reason, I think maybe they know what you're setting up, which is an appeal of their judgment, and they don't want to get overturned. So sometimes they don't want to make those findings. So in order to preserve your point of error on appeal that they didn't properly make those findings of fact and conclusions of law, you have to at one point submit a notice of late findings of fact and conclusions of law, basically telling the trial court, hey, you haven't done what you were supposed to do. I made this request properly. You still haven't done it. Another interesting thing to note about this is the trial court can do this on its own too. And if it makes findings of fact and conclusions of law, let's say shortly after the judgment issues, if they still have plenary power, they can still go back and amend those or make new findings of fact and conclusions of law, although they're not required to in that circumstance. So again, we can talk a lot more about this, but really important to do if you have a bench trial or an evidentiary hearing at the trial court. So now that we've talked about why you might appeal, what you can appeal, I want to get into sort of the mechanics of how you actually appeal a judgment. So what do you do? Well, you have to file a notice of appeal in the trial court. So this is just a filing that you file in the trial court. It's pretty straightforward. It's pretty simple. It's not a really big document. But I italicize here in the trial court. And the reason I did that is because if you look at the Texas Rule of Appellate Procedure that's on point here, it says to file it in the trial with the trial clerk. If you mistakenly file it with the Court of Appeals in order to effectuate your appeal, that is supposed to count. But I have recommended changing this rule to make it more clear, because to me, if you know you're supposed to file it in the trial court, but you intentionally file it in the Court of Appeals, to me, theoretically, the Court of Appeals could reject that because it knows that you did not mistakenly file it with the Court of Appeals. You filed it with the Court of Appeals knowing that you're supposed to file it in the trial court. I'm not sure how the Court of Appeals is supposed to know that. I think sometimes it's clear from the record. In practice, if you file it with either one, it'll probably count, but you're really supposed to file it with the trial court. So I would implore you to file a notice of appeal with the trial court in order to effectuate your appeal. But then also, right after you do that, file a courtesy copy of that notice of appeal with the Court of Appeals. And that's just a good way of letting them know that, hey, I filed an appeal. This is going to be coming down. The trial court's going to send notice, or the trial clerk's going to send notice. But it's letting the Court of Appeals know that this is coming, and it's something that they really appreciate. Once you do that, you want to file a designation of clerk's record. And this is basically a filing that you file with the trial clerk. And you say, hey, district clerk, if you were in district court, I'm filing an appeal in this case. Here are all the things that I want you to include in the record that goes up on appeal. And the clerk will create the record that the Court of Appeals will look at. And this is really important because when you file your appeal and you go through the appellate process and you write your brief and all that, the Court of Appeals can only look at things that are in the record. So that means in the clerk's record and in the reporter's record. And so there's a document or something that you want the Court of Appeals to look at, and you want them to consider when they're deciding your appeal. You want to make sure that's in the clerk's record. If for some reason you get down the line and you're writing your brief and you discover that a document that you want to cite from the record that maybe introduced into evidence or something, or you filed is not in the clerk's record, you want to supplement that as soon as possible. Because again, the Court of Appeals can't consider it if it's not in the clerk's record. And you also want to request a reporter's record, and you do that by directly contacting the court reporter from the hearing for which you want a reporter's record. That's usually if you had a trial or a bench trial or whatever, or that's usually the hearing transcript that you want, but you have to identify for the court reporter what you want. And then you have to file your request to the reporter's record with the trial clerk. And then after you do all that, you're supposed to contemporaneously file your docketing statement with the Court of Appeals, which is just providing them basic information about, the name of your case, the parties, whether you've gone to mediation, all that good stuff. The rules say you're supposed to do this contemporaneously with filing the notice of appeal. In practice, it usually happens maybe a few days to a week after you file your notice of appeal, and generally the Court of Appeals will give you a deadline by which you have to file that with the Court of Appeals. So when do you appeal? Generally, your deadline to file your notice of appeal is within 30 days when the trial judge signs the judgment, which is to be appealed. So this is important for civil cases. If you have a summary judgment hearing, let's say, and you have the hearing and the trial judge says, you know what, I'm going to grant this motion for summary judgment, but they don't actually sign the order granting the motion for summary judgment until a week later. Your appellate clock starts to run a week later after they've actually signed the judgment, right? So verbal orders from the bench don't really count for anything. So this is found in TRAP 26.1. However, post-trial motions, like the ones we talked about earlier, will extend the appellate deadline to 90 days after the judgment is signed. So if you file a motion for new trial, request for findings of fact, conclusions of law, motion to modify the judgment, something like that is going to extend your deadline to 90 days after the judgment is signed. However, that's not true for accelerated appeals, which are really generally interlocutory appeals, in which case your deadline to file that appeal is 20 days from the judgment, right? So if you're trying to file an appeal of a grant of a temporary injunction, you've got 20 days, and filing some sort of post-trial motion is not going to extend that at all. Restricted appeals, which again is a whole another topic we can spend an hour on. I've actually given a whole hour-long presentation on restricted appeals. That deadline is actually 6 months from the date the judgment is signed. And that's a really interesting appellate mechanism that we don't need to get into a whole lot here, but just know that that's out there. And that's generally if your opposing party did not appear at the hearing. So don't just think that you can get away without having an appeal filed, because they may file an appeal like 6 months later. Also be aware of TRAP 26.3. So let's say you went to the trial court and you're talking to your client, and your client's saying, okay, it's great that we won. Is the other side going to file an appeal? And you say, well, we got to wait 30 days and see. And there's no post-trial motion or anything like that. And you wait 30 days and there's no appeal, no notice of appeal. You go to your client and you say, hey, great news. Our opposing counsel did not file notice of appeal. We're in the clear. But 26.3 allows a party until 15 days after the appeal was due to file that notice of appeal, along with the motion for extension of time of the appellate deadline. I've seen this happen, and courts of appeals don't want to say, no, you can't file your appeal, and just shut the door on the appellant. They're generally going to allow them to file that late filed notice of appeal, as long as they file that motion for extension of time. They have 15 days after the appeal was due. And my experience personally is that if they file that notice of appeal within that 15 days, court's going to grant it. If it's more than 15 days after the notice of appeal was due, I think the Court of Appeals probably would still allow them to do that if they could, but at that point they don't have jurisdiction to do so. So really, if there's no post-trial motion, don't tell your client that they're in the clear until least 45 days has elapsed. So the actual notice of appeal, what goes into that? Well, TRAP 25.1D tells you what you need to include in that. You have to identify the trial court, state the case's trial number and style, the date of the judgment, and the order that you're appealing from. Sometimes there are multiple orders. You have to identify which order you're appealing from. Identify the party that's actually filing the appeal. State the court that you're appealing to. Again, unless you're in Houston, in which case you say it's the first court or the 14th court. You're not going to know that until you actually file your appeal and it gets routed to one of those two courts. If the appeal is accelerated, say so. So again, if it's included the jurisdiction, temporary injunction, something like that, say so in your notice of appeal. For restricted appeals, which we talked about, it's all those things plus you have to state that the appellant, person appealing, is a party affected by the trial court's judgment, but did not participate in the hearing complained of. So again, if you attended the hearing that produced the judgment that you're appealing from, you can't file a restricted appeal. You also have to say that the appellant did not timely file post-judgment motion, request for findings of fact, conclusions of law, or a regular notice of appeal. You filed any of those things, then you're deemed as having participated in the hearing and you can't file a restricted appeal. But if you didn't do any of those things, maybe you learned about a judgment, you're retained, you learned that your client has a judgment against it that was issued maybe 4 months prior, you may be able to file a restricted appeal, get 6 months from the date that the judgment is signed. The designation of clerk's record, again, TRAP 34.5A actually says what the trial clerk is supposed to put in the clerk's record. My suggestion is to, when you do your designation of clerk's record, list out everything that you want the clerk to include. So I would include everything that's in 34.5A, and then whatever else you want included in that, because the trial court clerk may not include every document that you want included in there. They may just include what the bare minimum is. So make sure you identify. I would enumerate and list out specifically what you want the trial court clerk to include in the record. Again, if you later discover, like when you're writing your brief and you're going to cite a document that you had filed that should be in the clerk's record, if you discover that it wasn't in the clerk's record, you need to file something with the trial court to supplement the clerk's record. That is on you. So even if you, in your designation of clerk's record, ask the trial court clerk to include something in the clerk's record and they made a mistake and they forgot, they didn't do it, whatever the reason, it is on you to have that record supplemented so that the Court of Appeals can consider whatever that item is that you wanted to consider in the court's record. For reporter's record, again, look at TRAP 34.6, send the court reporter a request in writing, identify the exhibits you want included in the proceedings for which a transcript is needed, and then after you do that, file that request with the court reporter with the trial court. And you want to make sure that you include that request for the reporter's record in the designation of clerk's record. That way, if you want to complain on appeal that, that there was no record taken or something like that, or the record was lost or destroyed, you can include that in there. You have to make that request to the court reporter. So after you file your notice of appeal, what comes next? Generally, if you're the appellant, your brief is due 30 days after the later of the clerk's record or the reporter's record is filed with the Court of Appeals, or notice that no reporter's record exists. The tricky thing about this is that sometimes the court will send you a letter, Court of Appeals will send you a letter saying, okay, the clerk's record has been filed or the reporter's record has been filed. And a lot of times when the second of those has been filed, the Court of Appeals will send you a letter saying the reporter's record has been filed, appellant's brief is due 30 days from today's date, whatever that is. Sometimes the Court of Appeals doesn't do that though. In which case it's incumbent upon you to, know when the clerk's record is filed, when the reporter's record is filed, so that you know when your briefing deadline is. So to that end, I would strongly recommend that if you have a case on appeal, you make a case mail account, which you can do if you go to txcourts.gov, and you go to one of the Intermediate Courts of Appeals pages, there's a case mail link on the left-hand side. If you don't already have an account, make an account, add your case to that, and that way you get email notifications when something happens with your case. So if something gets filed and there's a new deadline, you'll get notification of that. So let's say, when your brief is due, it's due 30 days, but man, you're really busy, you've got a lot going on, and you just need more time to complete your brief. What do you do? Well, you can file a motion for extension of time to file your brief. Courts tend to give you some leeway with extensions, especially the first couple of times you file a motion for extension of time. It used to be, not even that long ago, that most courts would be very generous with the first 2, maybe even 3 motions for extension of time. And a lot of times give you almost an automatic 90-day extension if that's what you wanted. When I did a lot of expunction appeals, sometimes, we had so many appeals that we were working on. Sometimes I would make my first motion for extension of time for 30 days. Sometimes I needed even more time, and I file a second request for 30 days. And those were almost automatically granted all the time. And sometimes even the third or fourth extensions were granted. I think that the courts of appeals have started to cut back on this a little bit. I don't think that they're being quite as, or at least all the courts are being quite as liberal with giving extensions of time. And one thing, when you file your motion for extension of time to file your brief, you need to explain why it is that you need more time. And it used to be that you could just say, well, I've got all these cases, and you would list out the cases that you have, the valid cases, the stuff in the trial courts. You've got a summary judgment hearing in a couple of weeks, and you've got another hearing, and you just haven't had that much time to do this. And I think that the courts are starting to look a little more skeptically at these sort of boilerplate motions that just say, I'm really busy, I don't have time to do this within 30 days. So be careful, and just, again, if you really need the time, go ahead and file it. You're probably going to get at least the first 1 or 2 extensions, but do be very thorough in explaining why it is that you need more time. Trap 10.5b tells you what you need to include in the motion. One of the things that you have to do with any appellate motion, including a motion for extension of time, is conference with your opposing counsel. And I will tell you, if you are on the receiving end of a motion for extension of time, if you're not the one making it, your opposing counsel is, and they confer with you, don't oppose it unless it's really going to prejudice your client. I mean, really prejudice your client, because more likely than not, the court's going to grant it anyway, even if you do object, and it's just going to make you look bad in front of the Court of Appeals. The Court of Appeals is not going to look kindly on, especially if it's the first or second extension. They're not going to like seeing that you didn't agree to it, and they're going to grant it anyway, most likely. So don't, a lot of times people will oppose it because they're upset that you even appealed it, or they just want to, take this sort of Rambo litigation tactic that they normally use in the trial courts at the Court of Appeals. But the Court of Appeals is really a different world, and they really don't like that sort of hard-nosed litigation tactics that you see sometimes in the trial court. Trial judges are a little more used to it, but the Court of Appeals really don't like it, and so just don't do that. Try to be accommodating to your opposing counsel. All right, so you're at the point where you're going to write your brief, and you're deciding how you're going to do that. So I'm going to kind of go over some brief, no pun intended, brief writing tips. Trap 38.1 tells you what you need to have in your brief, such as the table of contents, statement of the case, the issues presented, the index of authorities, things like that. But in terms of strategy for your briefing, the first thing I would say is try to limit the number of issues presented that you're putting before the court. So you might have 7 different issues that you think are appealable. Try to narrow that down to 1 or 2, at most 3 or 4. If you've got 10 issues that you put in your issues presented to the court's going to look at that and say, this is kind of a frivolous appeal, and even if you have some legitimate issues in there, the court's going to look at that and say, like, why are they doing this? Like, you want to keep the court's attention and make those issues presented really um, sort of narrow. So if there's one big issue, or just try to keep those as the number of issues as small as possible. When you're doing the issue presented, you might want to consider doing it as a deep issue. And what that means is a non-deep issue would be, the question presented would be whether the ABC statute is constitutional. That's not a deep issue. A deep issue would say this thing has been held by the Texas Supreme Court to be unconstitutional. The ABC statute dictates this thing that the Texas Supreme Court is held to be unconstitutional. Is the ABC statute unconstitutional? You're writing it and phrasing it in a way where the inevitable conclusion after reading those first two sentences for the court is that you are correct, right? So if you're trying to say that the statute is unconstitutional, you're going to phrase it that way in order so that the inevitable conclusion of the judge reading that is that, well, of course the ABC statute is unconstitutional. When you're writing, this is probably generally a good tip, but you want to be concise, right? You don't want to be overly verbose. Writing in plain English really does have a place at the Court of Appeals, and it makes it much easier on the staff attorneys and the judges who are reading your brief, and it makes it that much more persuasive. Make sure your citations are good. So I'm not just talking about your citations to case law and statutes. Be really intentional about citing to the record. So the reporter's record and the clerk's record. When you're citing the reporter's record, don't just put the page, put the line that whatever you're citing appears on in the page. So, page 24 of the reporter's record, lines 3 and 4. And also make sure you put the volume number. So sometimes there are multiple reporter's records, multiple volumes of reporter's records, and multiple volumes of the clerk's record. Make sure that you're identifying the volume that you're citing to, and then the page number. If you're citing to the clerk's record, there aren't always line numbers, but it might be helpful to put, what exactly it is that you're citing to, so that the court is clear what you're citing to, and be clear about what part of that, document it is that you're citing to. I should go without saying, but don't misstate the record or exaggerate what the record says. If you say that, this testimony, someone testified about this and said this, and you cite to the reporter's record, or if you don't, the Court of Appeals, the staff attorney, the judge is going to go look at that. And if they can't find it in there, or if it says, or if the testimony is not quite what you're portraying it as, you're going to lose a ton of credibility with the court. You're going to lose a lot of credibility. So don't do that. Be upfront and don't exaggerate, because again, the Court of Appeals is good. The judge, the staff attorney, they're going to look at the record. They're not just going to take your word for it. Now, again, those good record citations will help, because then the court will say, like, okay, you're supporting this thing you're saying by reference to this page of the record, and they're going to look at that. And if you're being honest about it, that will help your case a lot. But once you start exaggerating, you lose all credibility, and that's not something that you want to lose at the Court of Appeals, because then they're going to start questioning everything that you're saying. The other thing I would say is don't be afraid of putting tables and diagrams in your brief. A lot of people, when they get to the Court of Appeals, they think it's this very, rarefied place, and, it kind of looks like a law library, and, it's all about the writing, and it's very sort of elite law practice where you just, you rely on your written word and your advocacy skills in front of the court. And a lot of that's true, but don't be afraid to, put a table, showing, laying out complex facts, or a diagram that helps the court understand kind of what's happening. Those are actually really helpful to the court. And I would, if it's appropriate, I would highly recommend using those tables and diagrams in the brief. You actually put it in the brief. Kind of going back to being not using Rambo litigation tactics at the Court of Appeals. Don't take cheap shots at your opposing counsel. Sometimes, when you're writing discovery motions and things at the trial court, you may not be taking cheap shots, but you're kind of saying like, oh, well, I talked to so-and-so about this several times and they didn't respond, or I asked them to supplement their discovery responses several times and they didn't respond. You want to avoid doing that at the Court of Appeals. The Court of Appeals, you're generally just arguing about what the law is and how it applies to your case. So again, the Court of Appeals is a different place and they don't really appreciate the sort of sniping back and forth between attorneys. So don't do that. You'll lose credibility again if you do that. You don't want to do that. Think about what the relief is that you want the Court of Appeals to issue for you. Don't overlook that. A lot of times it's pretty straightforward. You want the court to overturn the granting of a motion for summary judgment. You want them to, grant the plea to the jurisdiction that the trial court denied, whatever it is. But be clear about what that relief is that you want and put it in the brief, put it in the prayer. Going back to making sure that things in the clerk's record that you want included are included, don't cite to things outside of the record. The Court of Appeals cannot consider it, and they're not going to be happy with you if you do that. So don't cite things outside the record. I'm not talking about like statutes and legal things. You can cite those. If you're talking about statutory interpretation, you're allowed to cite dictionaries, but don't cite factual things that are outside of the record. Keep your standard of review, your applicable standard of review in mind. And this is also something you want to keep in mind when you're talking to your client at the front end about whether or not you want to appeal. If you're complaining about an evidentiary ruling that the trial court made during your trial, the standard of review for that is abuse of discretion, because things happen quickly in the trial court and we don't want to second guess every single quick decision that the trial court has to make at the Court of Appeals. It's probably not worth appealing something like that. On the other hand, if the issue that you're bringing to the Court of Appeals' attention is an issue of law, let's say it's what's the correct interpretation of the statute, that's de novo review. That's much more helpful for you as the appellant, because then you basically get a clean slate legally for the Court of Appeals to look at your case. Not factually, the facts are still set in stone that you developed in the trial record, but if the facts are all laid out the way you want them in the trial court, and it's just a question about what the law is, that's really the wheelhouse of the Court of Appeals. That's their thing, right? And that's something that you're going to have a much greater likelihood of success with at the Court of Appeals. So keep that in mind. If you're interested in standards of review more, there's a really great St. Mary's Law Journal article that I would recommend. Here's the site for it. The authors really go through the standards of review in Texas appeals and kind of go through what each one of those mean. So what if you're the appellee? You're not the one who filed the appeal. You were successful in the trial court, and now you're on the receiving end of an appeal. What do you do at the Court of Appeals? Well, you don't have to do any work to get to the Court of Appeals. Once the appellant has filed their brief, you generally have 30 days to file your brief. And if you're the appellee, you want to emphasize the trial judge's discretion where appropriate, right? A lot of times the trial judge is granted a lot of leeway. And again, if there aren't like requests for findings of fact, conclusions of law, and there's just a blanket judgment saying this is granted or denied, and that's what the appellant is appealing from, the Court of Appeals is supposed to uphold that if they can find any way to do so legally that's supported by the facts and evidence. So, a lot of times the trial court gets a lot of discretion. You want to emphasize that there's not enough there to overturn what the trial court did. We don't want to, again, there's a general principle that we don't want the Court of Appeals second guessing everything that the trial court is doing. And so you want to, where appropriate, it's a factual determination or something like that, you want to emphasize the jury's findings and the trial court's findings were appropriate. And remember, you won in the trial court. Explain why the decision was correct and remember those presumptions again in your favor. You've already won once, so don't gloss over that. Don't waste your briefing on frivolous things. And I said things like jurisdictional arguments. Obviously, if there's like a plea to the jurisdiction, the granting or denying of a plea to the jurisdiction that the appellant is appealing from, I don't mean ignore those in your brief, but sometimes, people think that you filed an appeal too late and the court doesn't have jurisdiction, or the order is not a final appealable order. I've seen appellees focus their entire brief on, well, this appeal shouldn't even be here because it was filed late or the court doesn't have jurisdiction over it. There are a few reasons you don't want to do that. Number one is when an appeal is filed, the courts of appeals have staff attorneys again and professionals who look at the appeal to make sure that the court has jurisdiction. And if they don't think that the court does have jurisdiction, they'll say something and they'll probably catch it. But also, you can raise jurisdictional issues at any time. So if you really think that the staff attorneys missed something jurisdictional, you can file a motion to dismiss for want of jurisdiction before your brief is ever due, right? But you don't want to waste your entire brief on something frivolous like that. You want to address the merits because more than likely the court's already caught any sort of jurisdictional defect. If you're the appellant, you want to file a reply brief if you can. I know it costs your client more money, but it's such a good, you want to have the last word and you want to respond to the points that the appellee made in their brief. Don't re-argue the original points from your original brief, but do respond to the points that the appellee makes in their brief. Again, remember, you get the last word in this. You want to take advantage of that. So let's say you get oral argument. We're running out of time here. I want to leave some time at the end for questions, so I'm going to go through this fairly quickly. If you want oral argument, first of all, do you want oral argument? If you're the appellant, I think you generally do, if for no other reason, the fact that it will help focus the court's energy and focus on your case, right? I mean, the courts of appeals hear an enormous number of cases, they're deciding an enormous number of cases, but if they're granting oral argument and they're hearing oral argument, it's kind of a production, right? I mean, they dress up, they go to the bench, and they read the briefs beforehand and they come up with questions to ask you. So they're going to be focused on your case, and that's something that you want as the appellant. You want them to take it seriously and really think about it, and you want them to know it's not like the normal kind of case that they see. So if you want oral argument, make sure to say so on the front of your brief, and then you have to explain inside the brief why you think oral argument would be appropriate in this case. If you do get oral argument granted, which the court doesn't always do, even if both sides request it, but if you do, the court does grant you oral argument, go in with a game plan, know what you're going to talk about. And when you're up there, be respectful. Again, don't take cheap shots at your opposing counsel. Be respectful to the court. If the court asks you a question, stop talking. Don't talk over any of the judges. Be respectful. Don't regurgitate your entire argument unless you really don't know what it is that the court is looking for, but try to own in on the points that you really want the court to focus on, right? So if you've got 3 or 4 issues presented, try to focus on 1 or 2 of those issues that you think are really important. If you can, try to watch other oral arguments, especially from the court that you're arguing in front of. This used to be more difficult to do if you didn't actually go to the court and watch oral arguments, but now a lot of these arguments are still taking place over Zoom, and so it's a little bit easier to watch some of these oral arguments over Zoom. So I would definitely, watch those. You can kind of get a sense of what the judges are interested in, kind of how they ask questions, what kind of questions they ask, things like that. If you're going to use media like PowerPoints, confer with the clerk's office beforehand. Again, using PowerPoints and things like that during your oral argument, that's not necessarily a bad thing. Sometimes it can be very helpful to put diagrams and tables up there for the court to see during your argument. But if you're going to do that, make sure you talk to the clerk's office well beforehand. Don't just spring that on them when you get in there. That's going to be a big mess. But do consider doing that if you think it will be helpful. Be sure to directly answer any questions that the judges ask you. Don't avoid the question, right? I mean, so they're asking you those questions for a reason. And it's, if you're avoiding the question, it looks bad. It makes it look like you don't have a good answer, and maybe the judge is caught on to something that's really bad for your case. So the the B answer would be to answer the question directly. The A+ answer is answer the question directly and then fold that answer into your overall argument and use it to support your argument. Remember that sometimes less is more. You don't need to take the full amount of time if the substance of your argument doesn't warrant it. Sometimes I've seen very persuasive 5-minute arguments. It all depends on what it is you have to say, especially if you're the appellee. Try to think about why the court granted oral argument. The courts of appeals grant oral argument for all sorts of reasons. Sometimes it's legally complex. Sometimes it's factually complex or procedurally complex. Sometimes the law is just really complex. And sometimes the court just wants to grant it for some other reason. They think it's really important and they want the parties to feel like they have their day in court. Whatever it is, try to think about why it is the court granted oral argument and tailor your argument in response to that. Be prepared to discuss anything in your brief. I've seen people get thrown off a little bit because they wrote something in their brief and maybe they forgot about it or it was kind of a throwaway line, but the judges in the court certainly notice it and they start asking questions about it at oral argument and the litigant is completely unprepared to talk about it. So don't let that be you. Make sure you reread your brief before you get an oral argument and be prepared to discuss anything that you wrote in your brief. Make sure that there's not a case that you've overlooked because the court says, are you aware of this case? What do you think about this case? That's not really helpful to you. You don't want to be caught flat-footed because it doesn't look good. If you're going to rely on new authorities during your argument, submit a letter brief to the court beforehand. So as the court decides, if you like the result, great. If you don't, consider filing a motion for rehearing. If you do this, be respectful. Don't say, the panel was a bunch of idiots and they got it wrong. That's not going to make them want to change their minds about your case, right? Be respectful and explain why it is maybe they didn't consider something, or maybe there was some new authority that came out after the briefing that would support your position. You got 15 days to do that after the judgment. Again, if you're at a bigger court with more than 3 justices, consider doing a motion for reconsideration en banc. Again, 15 days after judgment. You don't have to do either one of these things if you want to appeal to the Texas Supreme Court, but sometimes it is helpful. If you do want to appeal to the Texas Supreme Court, you file a petition for review. So the way this generally works is you file a petition for review, then the court might request a response from the other side, and then the court will request briefing on the merits from the petitioner, the person who's complaining about the Court of Appeals judgment, and then there's a response and a reply brief. And that's all before review is granted, right? So the Texas Supreme Court is a little bit unique in that they request briefing on the merits before they actually grant review. But you want to focus on the task at hand, which is getting the court to grant review, and then focus on convincing the court that you're right. Because again, the Texas Supreme Court's court of discretionary review, and they don't have to hear your case if they don't want to. So basically how this works is, there's a petition for review, it's held for 30 days unless the other side files a waiver. It's sort of like a conveyor belt. It's automatically denied after about 31 days unless the justice removes it from the conveyor belt, triggering a court request from the other side for a response. It takes 3 justices to request full briefing on the merits, and then 4 to grant a case. And your goal is to convince the court that your case is important enough to take.